Morning, Your Honors.
Hold on just one moment. All set? Okay. Yes, sir.
Good morning, Your Honors. Attorney David Mirsky for the defendant appellant Joseph Lennon. This appeal involves appeal from a denial of a motion for new trial and an appeal from the conviction of first-degree murder. The most important thing about the motion is that we haven't heard evidence from the court on whether the type of closure that the defendant has presented evidence of in an affidavit, whether an actual finding that this doesn't occur or hasn't occurred. What the court did in the court's margin order ruling was basically say that it hadn't been reported for 3 years after the trial, but based on what the evidence that's been presented, there's a claim stated under Owens versus United States. It's a First Circuit case, 483 F. 3rd 48, and also under which is where when there's been a closure of the courtroom for 1 day of jury selection, there can be a public trial right violation. Also, under Commonwealth versus Cohen in this court, whether there's been a waiver is tied to the knowledge of counsel as to whether the courtroom is closed, and there's affidavits submitted that counsel was not aware of the closure.
But what do we make of the fact that all that we have here is a single affidavit from Mary Connolly with regard to, it's all premised on her, correct?
It's premised on her, but it's also premised on the transcript, which shows a full courtroom and that the judge was talking about there not being enough seats, and that in Mary Connolly's affidavit, she says that the door was locked. And so what there's evidence of through the record is a courtroom being locked because of an absence of seating, enough seating for...
No, she doesn't say that. We don't even know if based on her,
but that's,
whether the court's even in session. All it does, she looks in, she sees her brother sitting at a table. Let's assume it's counsel's table. The court officer opens the door a crack, says they're not letting anyone in the courtroom. She doesn't even say the court was in session. Nor does she say how long she was out there for. That's all we know is that for a single moment in time on that day, when the defendant was in the courtroom, she was not allowed in.
Well, what we know, Your Honor, what we know is that from that affidavit is the courtroom being locked. So we know the courtroom locked. She says that another person, a friend of the defendant she had seen, had been waiting there while she was that she had seen while she was waiting, had also not been able to get in. And that there's evidence that the courtroom was full. So I think you can infer that. And the point is that we have.
That's all he says. I spoke to a man who said he was a friend of my brother's who was also waiting outside the courtroom. It doesn't say that he tried to get in and was denied. We don't even know. This is day 2, I guess, of jury selection.
Right.
And it's not uncommon for the defendant to be in the courtroom when the jurors are being brought in the morning. Before, it takes a while to get to the jurors upstairs. I'm not sure if that's what occurred, but we know almost nothing here based on this affidavit.
Yes, Your Honor. The reason for the state of the knowledge is that the court did not make findings that this does not happen in Suffolk Superior Court. The Commonwealth did not, when faced with these allegations, did not say this. They're in this courtroom all the time, regularly. The judge has knowledge of what goes on in his courthouse and can ask court officers whether this has occurred in the past. These are things that were not presented and are not what are in a sense leave open the question, and that we can infer from what we have that there was a full courtroom, that a locked door was locked because there weren't enough seats, and that it was locked for the duration of the time in the transcript that jury selection was going
It
on.
doesn't even say how long, it doesn't even say whether she got in that day. We don't even know whether or not 10 minutes later she's allowed in. We just don't know that from her affidavit.
Well, we know from her sister's affidavit that she did not get in from that. She did not get in that day. That was the report.
I'm sorry, this is Pat Lennon. Pat Lennon, I was unable to attend. So she's basically saying, you have the hearsay statement of Mary. My sister did attempt to attend but was refused entrance during the jury selection process. That's more than Mary says.
Your Honor, we would have a lot more at a hearing. We would have an opportunity for this person who's being disbelieved, according to the Commonwealth's memo, should be disbelieved. We would be able to hear and examine her story and get more detail of what she would say happened that day. But what we have is enough for the court to look at this carefully and to make specific findings, to inquire itself of the courthouse and court personnel. We have enough evidence for the Commonwealth to report if they are aware of any instances where court security has closed the courtroom in that manner. Because under the case law, under Owens and the cases cited in Owens, if it only happened once and if it was done by a court officer on his own volition without a court order, it's still a Sixth Amendment violation of a public trial right. And so we need to hear all this, and it shouldn't be just dismissed because you have basically the judge is dismissing it because it wasn't reported for 3 years. Well, 3 years after the trial is Cohen and Presley, and although the public trial right exists prior to Presley from Waller, Cohen and Presley did make lawyers and courts and everyone more aware of the problems and the right, and that you couldn't just close a courtroom because it was convenient for the court. And so there's enough on the record for this to be looked into, and the manner in which it was addressed doesn't do justice to the fact that we're talking about a constitutional violation here. And in addition, it's not any ordinary constitutional violation. It's a structural error, and it's the type of error where where courts do not look at whether there was harmless error, whether the error was harmless, because that's what is behind every kind of doubt that you might have about a public trial claim. Well, it's only, what was the difference in the trial? What difference did it make? But we don't ask that, okay? And the reason in Owens, the First Circuit says we don't ask that because if we're going to apply a harmless error standard to this right, we're not going to have this right because it's never going to be considered harmful. So we need to know whether this whether this incident occurred, and we need findings and a determination in court the way as would occur when two people are saying opposite things. And in this case, we just have one person and is being doubted, but we're all entitled to hear what the judge and the Commonwealth have to say about this and what the actual facts are, because regardless of what I present, there's a fact out there, whatever happened in Suffolk Superior Court in 2007, and there's people that know, and there's people who have more access than I do to that, and for people that I can talk to, and I've recently, at the insistence of my client, attempted to contact court officers, and I on the 28th, I did speak with two of them, and they don't support the claim, but I would like the specific ways in which they don't support it to be on the record, because there are things that I would ask them, and I would like, and if the court is going to rely on that representation, I'd like to give the details of it. But I think that's the type of thing that should be done in an evidentiary hearing. And in addition, I'd like to point out that there was a specific officer that I was told by my client, this is not on the record, so I don't know whether it's appropriate, but I was not able to reach all the officers. So there's one that I haven't gotten to, and I think, it's a fact, and the court should be able to figure that out. I think there's enough on the record here, and if you look at Owens.
Okay. If I can turn, I want to actually discuss the voluntary intoxication issue. The briefs say almost nothing as to who this victim is and what, if any, relationship he had with the defendant. Is there any indication that they knew each other?
There are very sketchy facts here, Your Honor, and on the voluntary intoxication, I would like to say that there is a lot of evidence that the defendant may not have had the ability to focus his mind sufficient to be able to.
But is the evidence? I mean, it seems like the evidence of intoxication is alcohol on the breath. That's it. But then, when he is speaking to the police and he starts talking about the Bible, that's not really intoxication. That may be mental impairment. But I don't know that you tie that to or are you tying that to intoxication?
Well, Your Honor, the intoxication, he can have a mental impairment, but his intoxication can affect it.
There was no request for anything about mental impairment separate from intoxication, was
No, Your Honor. But the evidence is consistent with an impairment, being impaired, and there's evidence of alcohol consumption. And it's not just that it's that he began to ramble, wander, and digress, which is directly related to whether he could focus the mind.
But for the voluntary intoxication instruction, doesn't there have to be evidence of debilitating intoxication?
Yeah, Your Honor, that word debilitating is, I think, been expanded beyond. I mean, it may have a different meaning in vernacular. To the legal issue is really whether the person's impaired to any degree and whether that impairment is sufficient to affect an element. And I think that there's evidence enough here for a jury we had evidence. Sometimes he was steady, sometimes he was listing. We had evidence. The Commonwealth sought to address, it appears, the issue of intoxication in their questioning, but there is evidence for a jury to find that this person was too intoxicated to focus his mind. And in addition to the drinking, and I would say that the fact that he resided in a shelter for homeless persons can be considered, okay, and that he's not capable. He was
going to be drunk?
No, can be considered in terms of his mental capacity. He cannot be. He does not. His capacities have not allowed him to have his own home, to create a situation in his life where he has his own home, and that there can be issues of mental impairment. Issues are probably, for all we know, involved in any kind of intoxication. I mean, why are people doing that? Why are they getting intoxicated to that degree? To separate it out is not really a legal matter. It's a scientific matter that's not necessary.
If I can There's a reference in your brief to the testimony of Vincent Maloney, who is the Vice President of Facilities at the homeless shelter. And you write that he said the defendant listed or leaned as he was walking, and he described the defendant as off the wall. Was he referring to him as of his appearance on that date at 2 o'clock, or was that a description of him more generally?
I thought that was at 2 p.m.
At 2 p.m., right? But, I mean, I haven't gone back to the testimony. Is he referring to what his observation was of him at that point in time, or that this is how he generally viewed?
That's the way I understood it, but I mean, I could read it over and come to a different conclusion, but my impression from reading the transcript is that the Commonwealth was trying to establish his state of mind around the time of the alleged incident. So I thought that was the questioning. I don't think if it were related to an earlier time, it's not as relevant, obviously. And I would also just like to address the voluntary the fact that the intoxication instruction was requested, and that's part of the analysis. Also, I'd like to point out that the trial there's a third issue. The trial judge did not give the requested instruction on voluntary manslaughter. There is very sketchy evidence, and I would say the argument here is that there was enough evidence of mutual combat. It would be the bare threshold necessary to find reasonable doubt. There was a witness, Climax, saying they were kind of wrestling. Another witness, Mr. Charles Bois, heard yelling, angry voices coming from the direction where the defendant and the alleged victim were seated. And also there was that same witness said that there was the struggle. And it's not clear from the evidence exactly, there's no narrative really of what happened.
Well, didn't we have someone who took some photographs, a couple that was there, and they saw the victim sitting on a bench, and they saw the defendant walk behind him and pull him backwards over the bench?
Yeah, we have that, Your Honor.
Is that the mutual combat you're referring to?
No, I'm not referring to that separated out. I'm just referring to that there were varying witnesses from different angles. Some of them didn't see a weapon, or they saw something that looked like punching. There isn't exact evidence that is Mr. Elliott hitting the defendant, but there is evidence in the sense that of the word wrestling and the struggle that involves a mutual conflict.
Well, I guess my question is, did the wrestling occur after the victim was pulled over backwards over the bench and was on the ground, and the defendant was heard to say, turn over, turn over? Is that when the wrestling occurred?
I'm not clear on when the turnover part, and I think it's not exactly clear on the turnover part, but the person who said the testimony is about the struggle, that I noticed that the white male was standing right beside the bench, and then there was the struggle. The wrestling, I think, was tied to after they were on the ground. That comment. But I think that there's confusion in terms of what actually happened in the evidence. And the yellow light.
Yeah, you have about 35 seconds.
Okay, sorry, Your Honor. Also, I would like a review of the request to reduce the conviction to second-degree murder based on the evidence of diminished capacity, and I would refer to all of the facts in my brief. And I'd refer you to my reply brief with regard to the need for a hearing.
Thank you, counsel.
Thank you, Your Honors.
Good morning, Your Honors. Vincent DeMore on behalf of the Commonwealth. With me today is ADA Gretchen Lundgren, who's the trial prosecutor in this case. With respect to the motion for new trial and the denial of the motion for new trial, I think the court hit the proverbial nail on the head with respect to the evidence that was presented in the form of affidavits. There is only the one affidavit from Mary Conley, which produces any direct evidence, so to speak, that is to say, not based in hearsay, that anyone was excluded from the courtroom. And as was indicated, all she says is that she looked into the courtroom and could see her brother sitting at the table.
She also says it was locked.
She does indicate the door was locked and she was
Just from your experience, when was at that time the courtroom locked?
From my experience?
Yes.
I was in the trial units for 3.5 years prior to joining the appellate division. In my experience, the courtrooms are locked prior to the beginning of session for the day, usually in that 8:30 to 9 o'clock time period.
Not usually when the defendant is in the room.
No,
By
although
that time, it would be unlocked. It's usually either in closing argument, in the judge's instructions at the end, and at that time, I would suggest to you that it could well have been during jury impanelment.
while it certainly could have been, I think that would require us to speculate far beyond what the affidavit actually contains.
Well, that's why one might think that a hearing would be a good idea.
Well, I would suggest that if that's the case, then the gaps can be made up for. The failure of the defendant to produce any credible evidence can be made up for with that sort of supposition. And I think here you don't have that.
Was there an affidavit from the Commonwealth? I mean, the judge refers to one, and I don't find one.
There is not. The Commonwealth filed an opposition to the motion for new trial, but did not produce any affidavits. And I think the question of whether or not a remand is necessary, I think, does necessarily hinge upon the reading of the judge's actual order here. And I will acknowledge freely, of course, that the order itself is perhaps somewhat inartfully phrased. But I think what we have here is in the first sentence of the order, the judge indicating that he's essentially adopting the Commonwealth's rationale as to why the motion should be denied. And in this case, the Commonwealth's primary rationale is that the affidavit simply cannot be credited, that we have only one statement from a biased source, a family member of the defendant, and nothing in addition to that. The record is certainly silent on any courtroom closure issues. Both counsel for the defendant as well as that attorney's law clerk indicated that they were unaware of there being any issue whatsoever, that the defendant failed to produce any evidence from expected sources such as the court officers, such as other family members. There were 3 or 4 other family members who, according to the defendant's affidavit, did attend the course of the trial. We're not sure when or which days, but those people were certainly involved in being spectators at some point.
Do I understand from your argument, though, that even if you credit the Mary Connolly affidavit and that there was still not a problem that we need to be concerned about because it was only a partial closure?
Correct. It's a difficult analysis to make, certainly, based on the record we do have here. But as I outlined in the brief, I would suggest that the partial closure here, that if there was a partial closure, certainly if you credit Mary Connolly's affidavit and give it the full benefit of the doubt in terms of when that occurred, what was going on in the courtroom at the time, that there would be no problem under the Waller factors.
Well, except that you don't know what was happening in the courtroom. I mean, in other words, it may be that, at least as I've read the record, the judge said, as we go on, there will be room. And so we don't know when she came. And so we don't know whether, although at the beginning, clearly the record would suggest there was 0 seats. We don't know whether at what point there started to be seats because jurors were getting excused.
Correct. And I would indicate also that it is ultimately the defendant's burden to show these things.
Well, that's right, but we're not talking as though there's been a hearing.
Yes, but even the initial burden still lays on the defendant to make that showing. And here the defendant failed to do so. When you look at the cases where there have been remands for further factual findings, I think you're looking at a very different situation, a different record that had been developed at that point. In the Buckman case, the trial judge, or the motion judge, who, as I recall, was distinct from the trial judge, in his ruling, found that, or for the purposes of the ruling, was crediting the affidavit of the individual who was not allowed into the courtroom on that date. And I think that's a different situation, because there we have an explicit crediting of someone who claimed they were not allowed into the courtroom.
Also a family member, as I recall.
That's correct. And
So bias and all the rest of the things that the Commonwealth complains about with this were presumably also present there.
She ultimately didn't credit them when they testified.
Correct. But for the purposes of deciding whether or not there should be an evidentiary hearing in the first instance, the issue is whether or not, for that purpose, her affidavit was credited for that purpose.
But isn't that the point? I mean, I guess that's the problem I'm having. It's one thing for a trial judge not to credit an affidavit of a defendant, or the trials happened, somebody is now saying X when he or she said Y at the trial. Trial judges sat through the whole thing, and the appellate courts say, when the judge says, I don't believe that affidavit, we give that a lot of credence. In this is a very different situation. I mean, this is a family member who says she tried to get in, the door was locked, the court officer opened the door and said, the courtroom's closed, you got to go away. The judge doesn't have any experience with her. I mean, it isn't as though that she testified, I don't think. She testified at trial. I mean, in other words, it just seems to me it is a different, it's very different from the cases in which appellate courts have said, we credit the trial judge's disbelief of, somebody's affidavit in a motion for new trial.
Well, I'm not sure it's fair to say that the judge wouldn't have had any experience with her. She did claim to be present for each and every one of the other days of the trial, so she would have been.
She wasn't a witness, was she?
She was not a witness, but she would have been present in the gallery for all of those days. And certainly the judge would have been, conceivably would have been, if in fact this was during jury empanelment, would have been seated on the bench and could have had the opportunity to observe the court officer walk to the door and deny entry to an individual. But ultimately, that credibility determination is one that the judge made here.
Okay, but the problem you have is he didn't make that. I mean, what he said is that there's no credible evidence that any persons excluded from the courtroom during jury selection ever brought that fact to the attention of the court, counsel, the defendant, or anybody else. What he finds not credible, there's no credible evidence that anybody brought it to anyone's attention. That's different from saying there's no credible evidence that it happened.
I read the judge's order differently, and I think when you read it in the totality, I think a fair reading of that order is in the first sentence of that order that he's adopting the Commonwealth's opposition, which was primarily based upon
your affidavit, which doesn't exist.
Yes, as I indicated, I think it's inartfully phrased here. And obviously, I would suggest that in terms of the exact reading, it's upon review and for reasons set forth within the Commonwealth's affidavit, as well as the factual basis for those reasons. Obviously, the affidavit would be the factual basis. I'd suggest it's a transposition of the word opposition for affidavit in the handwritten margin note here. And I'd suggest that the second part of that, with respect to no one brought it forward, excluded is in quotation marks, which I'd suggest indicates that the idea is not being credited, that anyone was excluded, and that is simply another reason why the affidavit was not credited, was the failure to come forward for as much as 3 years until after the trial.
If I could turn you to the voluntary intoxication issue, what do we do with the testimony of the vice president of the homeless shelter, who, at least according to the briefs, have not gone back to the testimony, apparently described the defendant as listed or leaning as he was walking and as off the wall. Somebody who has, being in his position, would have experience, sadly, with a whole number of people who have alcohol problems at the shelter, and he's describing him as off the wall. Is that, and that's 2 hours before the stabbing?
It is, and that's the first fact I would point to, is this is a number of hours prior to the incident. So it may, if anything, rather, it does reflect his behavior and demeanor hours before the incident, as opposed to at the time.
2 hours before.
2 hours. He also, Mr. Maloney also agreed the defendant did not fall down, that he did not stumble, he had no problem standing up, sitting down, his voice was clear, and that all of the answers to his questions, the questions that he put to the defendant, were appropriate given what the questions were.
When was the post-event inquiry with the police interrogation?
It's
In relation to the killing?
It's impossible to say with absolute certainty how many hours had passed because it isn't clear from the record. We know that it was approximately 20 minutes from the time of the murder to when the defendant returned to the scene, and then at that point he was placed under arrest, transported back. His clothing was seized, swabs were taken, that process occurred, and it was after that that he was interviewed by the police. In terms of the timeline, it would require, some degree of suppositions to determine exactly when that occurred, as it is unclear from the record.
Is there any evidence as to the physical condition of the defendant as he was allegedly running away from the bench in the scene of the crime?
There was a video which showed his flight, so there would have been that visual evidence directly of how he was.
Was he stumbling or was he running
there was evidence that he
in a coordinated manner?
Yes, there was evidence that he ran away, and I'm afraid I can't say with certainty without anyone testified that he ran in a straight line or with no issues, but he certainly was able to run away. And directly prior to that, he was able to pull someone over the back of the bench after having walked behind the bench himself with no difficulty, stepped over a chain which acts as sort of a fencing, and was then yelling at the victim in a loud, clear voice with no slurring of his speech, and then fled. Certainly then had the presence of mind to change his clothing, and when he left the veterans shelter 20 minutes after the murder, he walked up the stairs with his hands in his pockets, obviously not requiring a railing to steady himself. And I'd suggest if he was intoxicated to a debilitating point, he would have required at the very least a railing to walk up those stairs. In terms of the evidence that there was here, the only evidence that the defendant can point to with respect to any degree of intoxication is his own statement that he and another individual shared a pint of vodka that day. There was an odor of alcohol which was described as mild at times or was undetectable by other witnesses, and his statements or his interaction with Mr. Maloney prior to, and then his quotations from the Bible during the course of the police investigation or police interview. To suggest that all of that is enough for a voluntary intoxication instruction in some ways would be simply to say that evidence of any consumption of alcohol gets you there. Because in my view, this is about as low as you can get in terms of any sort of impact on his ability to comport himself. Obviously, we can't look inside of his...
Is there any case which has had this type of evidence which has supported not giving an instruction? I mean, you cite Del Valle and Erdeli, but both of those are much less than here. According to the defendant, and this is Erdeli, he took 2 sips of beer and then took a taxi cab home. The defendant said he was sober on the night in question, so that's Erdeli. And Del Valle, I think also had very minimal evidence of intoxication. Is there any case in which there has been evidence of this type in which we've said the judge need not give it?
There are 2 cases cited in the Commonwealth's brief, Ellis and James. In the first one, it was ingestion of a combination of marijuana and embalming fluid. And in James, there was evidence that the defendants had engaged in a beer drinking competition prior to the murder. And I'd suggest that those would reflect a much higher level of intoxication, certainly the combination of marijuana and embalming fluid, than what we have here.
There was evidence that the defendants were part of a group that had consumed several bottles of beer before they attacked Harbor. That's James. Mm-hmm. But the problem here is that you have, it's the testimony of this vice president that is the one that's most troubling to me, about him being off the wall. I'm not sure what the context of that was, but what do we do with that?
I think that's one of the things that the defendant can point to, but I think you take that and you compare that to the other testimony that Mr. Maloney gave, which indicates that in every other respect the defendant was fine. that he was able to respond, his speech wasn't slurred, that physically he was able to handle himself in terms of standing up, sitting down, he wasn't stumbling. The phrase off the wall by itself, I would suggest, doesn't necessarily connote a level of intoxication. One can be off the wall if they're animated, upset, if they are enraged or infuriated by whatever is happening in front of them. Well, I don't believe there's any direct evidence or any evidence with respect to the substance of that conversation. I think it's also a fair inference that whatever the substance of that conversation is could have angered or upset the defendant such that he might act off the wall. With respect to the third issue raised by the defendant with regard to the voluntary manslaughter instruction, here I think that the trial court was entirely correct in refusing to give that instruction for a number of reasons. Most importantly, no reasonable view of the evidence here would show that there was mutual combat or reasonable provocation. The angry voices that the defendant points to, in order to tie that to the defendant or the victim for the purposes of mutual combat or reasonable provocation, ultimately requires speculation on the part of the jury. No one could tie those voices to those individuals. They're simply coming from the direction of those two individuals. No one observed them actually say these words or hear these words. This is 4 o'clock in the afternoon in June by Union Street in Curly Park. And the photographs that are admitted into evidence show there are dozens upon dozens of people walking around there. To make the leap that these angry voices must have come from those two individuals such that a reasonable view of the evidence shows reasonable provocation requires one to speculate that, in fact, that's where they come from. And that sort of speculation isn't something that we permit. With regard to mutual combat, the only evidence there is there was the wrestling or the struggle. Those same witnesses also made clear that the victim never made any threatening moves towards the defendant, never raised his hands, never struck the defendant. I think the idea that there would be some wrestling or grappling after the defendant had pulled the victim up and over the bench, I think doesn't necessarily suggest mutual combat. If anything at all, it would be an effort by the victim to defend himself. And in the photograph that was admitted into evidence, which shows essentially the moment of death when the knife was inside the victim's back, his hands are down on his on his chest, not even in a defensive posture at that point. And of course, also with respect to the voluntary manslaughter and the voluntary intoxication instructions, they are completely contrary to what the defense was here. For lack of a better term, I characterize it as a misidentification defense, but it wasn't quite that. It was that he was a good Samaritan in that photograph, perhaps attempting to stabilize the knife or remove the knife. That there was, while he denies ever being at the scene when he talks to the police officers, the theory at trial was that, yes, he was there. And those instructions are totally contrary to that defense.
So are you saying that unless the defendant concedes that he did the act, he doesn't get the instruction?
No, I'm not necessarily saying that's the case. But where you have such minimal evidence of either voluntary of intoxication or mutual combat or reasonable provocation, the fact that that was indeed not the defense, I think, cuts in the favor of the judge not giving that instruction. So for the reasons stated in the brief, also with regard to the 33E, I would ask that this Court, in its search of the record, and as well as any considerations that may mitigate this, remember that this is a case where an individual walked behind someone and stabbed him in the back with a 14-inch or 13-inch bayonet with an 8 or 9-inch blade, such that it pierced the lungs, the heart, and lodged in the front of the victim's rib cage here. And in that one single blow, ended this individual's life. And I would ask that the Court affirm the convictions. If there are no further questions, I'll rest on the brief.
Thank you, sir. We'll take a brief recess.
All right, please stand.